Go on.
Madam Deputy President.
The Opposition Leader.
On behalf of the Labor opposition, I rise to oppose the third reading of the bill, and I move to amend the question before the House as follows. I move, quote, that the question be amended by omitting be now read a third time, unquote, and inserting instead, quote, be referred to the Standing Committee on Law and Justice for inquiry and report, unquote. Madam Deputy President, in speaking to the amendment and the third reading motion, as it's now before the House, I say as follows. Those on this side of the House and some of the crossbench have worked diligently and constructively to try and improve what is a terribly flawed and oppressive piece of legislation, to try and make it better adapted to the ends to which the government claims it is directed, to try and make its measures more proportionate to the concerns upon which they are said to rest. Sadly, despite our best endeavours, this has not proved possible. The legislation before the House remains directed to preventing legitimate peaceful protest activities by law-abiding members of our community, to criminalising activities that today are completely legal but which, if this becomes law, will expose farmers, knitting Nannas and citizens from the wider community who are acting to protect their land, water and food integrity to jail penalties of up to 7 years under the expanded definition of a mine that will now extend to coal seam and other unconventional gas operations. But the pervasive and sinister provisions of the bill are not limited to CSG or to mining or even to trespass, although it certainly covers those matters. The legislation still contains new police powers to disperse peaceful assemblies unless authorised under the Summary Offences Act. It still contains new powers to stop and search persons and vehicles without any warrant on the basis of mere suspicion, to the seizure of property without due process or protection by the courts. Whether or not those opposite acknowledge this, this legislation strikes at the heart of a fundamental aspect of our liberal democracy, the right to peaceful protest, to signify community feeling in opposition to government policies and actions with which they disagree, and by such means to hold governments to account, to change not only the minds of governments, but of those in the wider community. In short, to change society for the better. This crucial capability has brought about many of the best advances in our society, without which we would be a much less equal and harsher community. The right of women to vote, Aboriginal self-determination, and many of the improvements in human and legal rights for the whole community, including those in the past oppressed by the structures and laws of society, working people, those of non-English speaking backgrounds, gay men and lesbian women, to name just a few. If our society is to remain free, if we are to retain and bequeath to future generations this important avenue for social and political discourse of progressive and peaceful social change, we must not restrict or diminish the right to assemble and to protest, which this bill clearly does. The measures contained in this bill are not proportionate or reasonably adapted to the objectives to which it is directed, as required by the implied freedom of political communication laid down by the High Court in authorities such as Longy and Unions New South Wales, which is why we are of the view that a short review by the Law and Justice Committee is both warranted and prudent. These matters that we are discussing, Madam Deputy President, I think are usefully illustrated by the decision of the High Court of Australia in R versus Neil, 1982-149 CLR 305. That case involved Mr Neil, an Aboriginal man. He was the council chairman in Yarrabah, a community in northern Queensland. This community had a deep sense of grievance about the paternalistic treatment by white authorities, including the management of the store, which was reportedly selling rotten meat. Mr Neil had argued with the store manager about the management of the reserve, and when the discussion reached an impasse, Mr Neil swore at the store manager and spat at him. For this, Mr Neil was sentenced to 2 months hard labour. On appeal to the Queensland Supreme Court, Mr Neil's sentence was increased to 6 months. Mr Neil then went to the High Court of Australia. In particular, I draw members' attention to the judgment in that matter of the late Justice Lionel Murphy on page 317, and I quote, that Mr Neil was an agitator or stirrer in the magistrate's view obviously contributed to the severe penalty. If he is an agitator, he is in good company. Many of the great religious and political figures of history have been agitators, and human progress owes much to the efforts of these and the many who are unknown. As Wilde aptly pointed out in The Soul of Man Under Socialism, agitators are a set of interfering, meddling people who come down to some perfectly contented class of the community and sow the seeds of discontent among them. That is the reason why agitators are so absolutely necessary. Without them, in our incomplete state, there would be no advance towards civilisation. Mr Neal is entitled to be an agitator, unquote. The entire court joined with Justice Murphy in overturning Mr Neal's harsh treatment by the Queensland courts. What Justice Murphy and the High Court are saying to us, even today, is that those who agitate, who dissent, are often challenging characters and often cause discomfort to those around them. But what they do is necessary for society to continue to evolve in a positive way. For these reasons, the Labor opposition rejects this legislation, even as amended, and we press the amendment on the House.